Hi, this is David Rubin. Today, what I'm going to talk about in this video is the discovery process in a contested divorce and/or custody case. And the discovery process, I think, in my experience, I've been doing this for 27 years, is probably the most difficult thing people have to face when going through a contested divorce case. So what is discovery? Discovery is the process of each side finding out about what the other side's case is going to be. Divorce court is not like TV, and most court in real life is not like TV. We exchange information before the trial for two reasons. One, so that nobody's surprised when we get to trial, and two, it encourages people to settle the case. So this is the process in a contested divorce case. Let's say your spouse has filed for divorce or you filed for divorce and you have not agreed on the issues yet, whether it's alimony that you're fighting about or marital property division or child custody or child support or any other family law issue. Somebody initiates the process by filing a complaint. And then the other person comes in and they say, hey, I'm going to file an answer and I don't agree with what you want. This is what I want. So at that point, the lawyers, for the most part, are required, in order to what we call do our due diligence, to send out discovery. The court's going to give us about 90 to 120 days to do this process, and oftentimes it can get very expensive, unfortunately, and it's one of the major expenses of contested divorce litigation, and it's why it's always better to try to reach an agreement before you get into this process. But what discovery means, it's a way for you to discover the other person's case. In Maryland, we have two means of discovery that we always do in cases, and sometimes we do a third, and sometimes we even do a fourth. The first is what we call interrogatories. Interrogatories comes from the word interrogate, are questions. In Maryland, and I always say in Maryland because this is Maryland and I never want to speak for another state, and I don't practice in any other states, but in Maryland we send out interrogatories, and our rules say that we have 30 questions that we're permitted to ask the other side. People look at these questions and sometimes they're just dumbfounded by it. They feel like they're overwhelmed by it. You know, when you're going through a divorce situation and a custody situation, you're already in a heightened state of emotional, disarray. Everybody is. And then they have to deal with these questions that something they've never seen before, unless they're already a paralegal for a law firm or something like that. These questions that ask personal information. It starts out easy, name and address and social security number, and it asks usually for, what your job is and how much money you make. And it's these things that you're never really used to talking about, but you have to provide this information. And the number one question that my clients always say to me is, well, is she going to have to provide this same information? Is he going to have to provide this same information? Why do I have to do this? And the answer is because, unfortunately, this is the way it's done, and this is the only way we can prepare for trial. So there's generally 30 questions, and what we always advise people, always, in every case, is be as thorough as possible. Don't shy away from it. Don't try to hide information. That never helps. Give the information to us, and then we prepare the answers for you. That's what interrogatories are. Then there's something that's even worse. It's called request for production of documents. In Maryland, there is no limit to how many documents you can request from the other side. So we all use forms. Some of us have forms that ask for 100 requests. Some of us ask for 200 requests. Sometimes they duplicate each other. And what do you mean by documents? I don't have any documents. Well, what that means is you've got to provide income information. You've got to provide pay stubs. You've got to provide tax returns. You've got to provide bank statements. You have to provide credit card statements, and on, leases. And then the other kind of documents that are very frequent in divorce cases are photographs or videos or Facebook posts or text messages or emails or things like that. So it's all financial documentation, and it's all other documentation that you might want to use in trial to support your case. So why is it important that you respond to these requests for production documents in detail? Well, the reason is, one, because if you don't, the other attorney is going to say you haven't followed the rules, and we're going to try to limit the way you participate in the trial. In other words, if you don't produce a video or a picture that helps your case, my spouse keeps the house a mess and they shouldn't get the house, or something like that, and that's just a silly example. But if you don't produce it in discovery and you show up to court one day and you try to say, look, judge, look at this picture. The other side says, objection, you didn't provide that in discovery. And that's a valid, that's a valid objection. Same thing with answers to interrogatories, like I talked about before. You've got to give the information to the other side, and this is for the most part. There are certain things that you don't have to, and we can always talk about those. Certain things go beyond the scope, and they're so irrelevant or so harassing you don't have to deal with it. For the most part, this is what the discovery process is. So it's the process of exchanging information prior to trial. And what the courts try to do is they try to get everybody to exchange this information at least 60 days, 90 days before trial. The goal then is, okay, I know your case, you know my case. Let's try to sit down and try to resolve these issues. And if we can't, we'll go to trial, and we'll do it that way. Something else that we do sometimes is what's called a deposition. We do the interrogatories, we do the request for production of documents, but sometimes we want to get the person in our office and ask them questions before trial. We want to know exactly what they're going to say, perhaps understand their demeanor, find out more information from that is going to lead us to other information. Obviously, this depends on the complexity of the case. Certain cases are not complex at all. You don't need to do this stuff. Some cases are extraordinarily complex. There's businesses. We have to find out business records and owners and stock agreements and whatever it might be. We might need to bring in somebody who the person's had an affair with and bring them in the office and find out exactly what they're going to say. So every case is different, but this is what the discovery process is all about. And it's always going to happen in a contested divorce case. So we've done this in many, many cases. It's very new to you, and we understand that. If you have any questions about divorce, if you have any questions about the discovery process specifically, feel free to give us a call. We're always here for a free consultation initially. Answer any questions that you have. We look forward to helping you.